Hey everyone! In this episode I am going to interview Professor Nele Matz-Lück. She's professor here at the University of Kiel for Public and International Law, and also she's co-director of the Walter-Schücking Institute for International Law. Also, she's part of the Excellence Cluster Ocean of the Future and specialized in maritime international law. So let's dive right into the interview.
What is the mining code of the ISA, and how does it regulate different kinds of deep-sea mining?
So the mining code is the more specific regulation on what you can or have to do if you want to explore or exploit mineral resources. We have to work our way down from the more general legal regulation in Part 11 of the Convention on the Law of the Sea that regulates what is the ISA, what is a sponsoring state, what are the responsibilities. But when it comes to specific resources, different resources, and specific activities, the regulations are adopted by the International Seabed Authority. So that gives a bit more flexibility to keep up with developments, to have specific rules for the different kinds of mineral resources, and all this together forms the mining code.
Which requirements do applicants have to fulfill if they want to get a mining license from the ISA? And can everyone get a license?
Not everyone can get a license, so that's first. At the moment we're in the stage where contractors have exploration licenses. So the exploitation regime is under development because commercial mining hasn't started yet. For exploration licenses, there are specific requirements that you have to do environmental impact assessments and so on. And so this will be mirrored by the exploitation regulations. And not everyone can get a license. So-called contractors first need to find a sponsoring state. So there always needs to be a member of the Law of the Sea Convention behind the contractor. So contractors can be private companies, can be state-owned companies, but we have a triangle of relations: the ISA, the contractor, and the sponsoring state. And they do have to fulfill certain requirements, and they do have to have an agreement with a sponsoring state.
How can or does the ISA sanction applicants who do not adhere to the rules of the license? And are there any internationally binding instruments to sanction states or public bodies who fail to fulfill their duties while mining, just like a crime against humanity? Or is it even possible to take someone to international court in this regard?
That's a very good question. Let me start by saying international law is usually quite weak on the consequences. For seabed mining, we do have a liability regime. So contractors are bound to comply with the license. They are liable also to pay for damages if they do not fulfill these requirements. In the end, if the sponsoring state hasn't complied with their due diligence obligations to supervise the contractor, they can be liable as well. But there's no automatic response or no automatic sanction regime in place. There's a particularity that before the Seabed Disputes Chamber of the International Tribunal for the Law of the Sea, not only states can make claims, but also individual contractors. So also disputes between the contractor and the Seabed Authority, or the Seabed Authority and a state, can be brought to the Seabed Disputes Chamber. But there's no comparable individual sanction regime like a crime against humanity. So there's no individual criminal liability under international law.
Is it likely to be there in the future?
No, I don't think so. I think if commercial mining will start, we will see cases at the Seabed Disputes Chamber. We will see more. So far there haven't been really any cases where the contractors have been held liable for damages or for non-compliance. But this is likely to change if we enter into a commercial mining phase. And I think then we will see cases at the tribunal in Hamburg.
How would you judge the conflict of the ISA between its task of environmental protection and justice and the urge to earn money through licensing? And how successful is the ISA, therefore, with safeguarding the ecological effect of deep-sea mining?
That's a tricky question because the ISA is not an environmental protection agency. We quite strongly focus on these aspects at the moment, also because of the safeguards that are incorporated into the regulations on commercial minings, all this environmental impact assessment, management plans and so on that we already have in the exploration regulations. But the ISA is an authority to enable mining and to provide for mechanisms that the benefits of mining are shared between potentially all humankind. We have the common heritage of humankind principle for the resources of the area. So I think it's a misunderstanding to think that the primary obligation of the ISA is to protect the marine environment. It's rather to find some kind of trade-off or balance, and the ISA is doing that by setting aside, by reserving certain sites where mining shall not take place. The enterprise as such, so this commercial body to explore and exploit resources on its own has not been established, so the ISA does not have its own mining company at the moment, but it potentially could. It's a balancing. I think the ISA is aware of its responsibility to have environmental safeguards, and there's strong lobbying from different sides to bring in expertise on that, but it's not an environmental protection agency.
How would you judge the upcoming task of the ISA to maintain, or more so establish, a global governance of deep-sea mining? And how can countries, especially those who buy a license, contribute to it? And how would you judge the legal development of deep-sea mining in the near future?
I think it's an ongoing process, and the ISA is central in developing and further developing and adapting the mining code. So at the moment we're in a stage where we do not have commercial mining yet, but we are developing the regulations to have them in place when mining starts. So that's a good thing, because usually the law reacts to situation. A lot of environmental legislation only reacts to catastrophes and then tries to prevent that for the future. So the ISA is central in that. I think that the states who are sponsoring states, or who are, well, if we have state-owned contractors, they are actively engaged in the process of further developing these regulations. And this will, I don't think the mining code will ever be really finished. We will see revisions, we will see adaptations, but a lot depends on whether commercial mining actually starts. And that's not a question of having the legal regulations in place, but of it being economically feasible. So if we feel we need the resources and we can put them on the market from deep seabed mining, then the process will start. And then states are even more asked to revise and keep under supervision the legal regulations to be able to adapt them.
Are there any conflicts already over mining zones in the deep seabed or over licenses? And how would those conflicts possibly be solved in the future?
There was a concrete conflict between Germany and India in the Indian Ocean over exploration areas. So usually the areas for exploration and later for exploitation will be suggested by the sponsoring states, and then the ISA chooses the sites. So in the case between Germany and India, I think Germany withdrew the application for that specific area. How this is going to be solved in the future when several states try to claim a specific area, I don't know. Maybe it's a first come first served basis. There will always be the possibility to have a dispute settlement, and we shall not forget that at the moment, to respect the rights of developing states, the sponsoring state suggests 2 sites, and the ISA then gives a license for one and reserves the others for developing states members. There is a potential conflict with areas that the US have claimed. The US is not a member to the Convention on the Law of the Sea, so not a member to the International Seabed Authority, but they have some old reserved areas from the time prior to the seabed mining regime. So far, I think one area has been given up by the US, and in the others, the ISA has so far not granted any licenses, but that could be a potential dispute, and then we would have to see what are the rights of the US as a non-member.
Okay, that was it. Thank you so much for taking the time for this interview, Professor Matz-Lück. And to everyone watching, I hope you're now even more interested in maritime international law. And see you in the next episode. Bye!